Okay, this is Wilson versus Auto Owners Insurance Company and Homeowners Insurance Company, docket number 16-913NF. This is the time set for hearing on the plaintiff's motion for partial summary disposition. And I will have you all put your appearances on the record first.
Good afternoon, Stephen Sinus on behalf of plaintiff.
Good afternoon, David Nelson on behalf of defendant. Sorry, John, I jumped the gun there. Go ahead.
Jonathan Homa, also on behalf of plaintiff.
Okay, and now your motion, Mr. Sinus. I'm told you're arguing this. You can go ahead.
May it please the court, thank you for the time today. We have been before the court on this case on numerous occasions over the past several years. And so here we are again. Our motion for summary disposition attempted to summarize this court's orders and providing the procedural background. I'm more than happy to answer any questions the court may have about any of that, but I assume the court is aware of what has gone on. And we rehashed some of this about a month and a half ago when we had some discovery motions before the court. So going into our motion for summary disposition, it begins with the recognition that there were some significant rulings from this court after it found that Myron Wilson was entitled to no-fault benefits. This court issued a very important ruling that with regard to his medical expenses that were paid by Medicaid while the dispute over no-fault was going on, whether auto owners had the legal obligation to pay the reasonable charges for those medical expenses, or was auto owners limited to what Medicaid paid because of the incurred requirement and the way the Medicaid code was written, whether that allowed auto owners to that kind of set off, if you will, or what I would maybe pejoratively refer to as a windfall, but however way you want to look at it, they were looking to use the incurred requirement and the Medicaid statute to say that their liability is essentially capped at the Medicaid reimbursement rates. This court, in a very thorough ruling, we provided the transcript to remind everybody what the reasoning of this court was, and it was clearly it ruled against auto owners and clearly found that despite the fact that Medicaid paid, despite the word incurred in the No Fault Act, once the big picture is considered in terms of the case law regarding the incurred requirement and the Medicaid statute and the whole situation where you have the two systems at play, it doesn't lead the insurance companies to the result that they are capped at Medicaid, and this court determined they still are liable for the reasonable charge. And so with that being understood, we went ahead and tried to litigate over this issue. And the discovery battles that I was referring to that we came before the court on were with respect to where things stood with the reasonable charge discovery. And throughout the course of discovery, we provided expert testimony that explained that we were taking the position that the medical expenses at issue were reasonable charges because they were based upon the 80th percentile margin known within the medical charge world. That the expenses at issue were consistent with 80th percentile. And we had a medical billing expert provide an affidavit, a report, included data, and then that expert was deposed by defense counsel. And so we put forth our information about why 80% is reasonable. Along the way, we asked the defense to provide discovery responses to interrogatories that were served, I think, all the way back in 2017. About what they considered to be a reasonable charge. And to this day, those responses have not been answered to in any specific way. We brought to the court's attention that they weren't responded to along the way in conjunction with our previous motion to quash subpoenas. But as we sit here today, those responses have never been supplemented in any formal way. And what we have here is their response in light of all this. And their response is largely predicated upon rehashing the arguments that they already made in the previous motion. And I mean that as a matter of fact. If you look at their argument in one, they say they don't have to pay these charges because they are not incurred. They cite case law and essentially rehash the same arguments that were in their initial motion that this court decided over 2 years ago. And so that's the fact of the matter, that they are bringing back this incurred requirement as the major basis upon which they are challenging our motion for summary disposition. Their second argument is that's on page 17 of their brief after they rehash everything that this court already rejected. is somehow saying that there's a conflation going on with our expert between reasonable and customary. They provided no analysis that really supports what they're saying there. And there's been clear testimony by Mr. Miller about how he believes this 80th percentile margin is both reasonable and customary. And his thorough explanation of the data and his reasoning behind his opinions is clearly before the court. And I would submit to the court, certainly does not give them grounds to create an issue of fact just out of that. There's not even a legal, I think, basis explained for what they're saying in their brief. And when it's all said and done, that is not adequate grounds to deny our motion that there is no issue of fact. With respect to whether there's an issue of fact, they cite to a case known as the Spectrum case that was decided in September. At no point have they ever asserted that Spectrum was somehow the basis of their challenge against our argument against reasonable charge. They've cited it as somehow playing into what creates a question of fact here. But I just want to say a few things about this case. First of all, the context of this case, or the Spectrum case, was that Farm Bureau Insurance paid 80% of the hospital's charges. The hospital wanted the additional 20%. And the litigation was very much focused around a reasonable charge dispute in which specific discovery was sought by the insurance company. A specific fight was waged over the reasonable charge argument, where clearly a record was made that Farm Bureau was getting into the nooks and crannies of every financial aspect of these providers. And it came before the Court of Appeals. And I will note to the court, it is pending before the Supreme Court on a leave app, but it came to the Court of Appeals and it issued its decision that given the fight that Farm Bureau had raised over how much this hospital should be paid, when the statutes look at it more closely, when you're talking about the customary aspect of the statute, the court allowed for Farm Bureau to bring in the evidence, these other rates of reimbursement that it specifically sought in discovery, that it specifically said was the basis of its dispute in terms of the reasonable charge argument. What we ultimately have here is auto owners always rejecting what this court has ruled, believing that the incurred requirement and its position on the Medicaid statute saves it from its liability. And as far as I know, they intend to take this up on appeal on that issue. And so I say, let them. And when it comes down to the rest of the litigation of this case, why waste everyone's time and effort going through a trial on reasonable charge when they've never asserted a defense that's a proper defense asserted in response to our discovery request under Michigan court rules? Why are we going to go through that process when obviously, as indicated in their brief, the issue with them is the incurred requirement and the Medicaid regulations? So with all that being said, they have not created a question of fact. We have thoroughly tried to prove our case, and there really is no reason to have a trial on this one issue of reasonable charge. And that's why we respectfully request this court to grant our motion.
All right, thank you. Mr. Nelson?
Thank you. First of all, there have been several developments that have occurred since the rulings that this court made a while back, and two were two depositions of Miller, as well as a deposition of a biller from the Marquette General. And second was the fact that homeowners paid Medicaid the amount that they claimed was owed, and Medicaid was subsequently dismissed from this action. Now, those two events, if you look at the deposition testimony of Marquette biller, who reaffirmed what has been argued in the past, that they can't legally bill Mr. Wilson for any balance on this claim. Even their expert, Miller, agreed with that fact, that they can't bill Wilson for this because when you accept a Medicaid payment, you're prohibited from doing it. And then the fact that homeowners paid Medicaid this amount and Medicaid subsequently dismissed, that begs the question of what legal right is Mr. Wilson actually pursuing in this case? And I mean, I do recognize the arguments that Mr. Sinus made and this court's ruling regarding the incurred requirement. I respectfully disagree with that. But at that time, I think there was a potential issue that Mr. Wilson may have been on the hook for it because homeowners hadn't paid Medicaid. Medicaid hadn't been dismissed. Subsequently, you have Medicaid who's been dismissed. They can't go after Wilson. You've got the billers from Marquette saying they can't go after Wilson. And under Medicaid law, they can't go after Wilson because they already accepted the payment. So you really have Wilson trying to pursue a claim, a legal right that he's not going to be held liable for. So, I mean, and to the extent that the court, I mean, I'm sure this court's aware, a court can revisit prior arguments at any time, depending on the evidence in the record. There's case law that establishes that. So I think there's subsequent developments that have occurred that simply reaffirm our arguments that Wilson has not incurred these expenses, and he essentially has no stake in this claim because nobody can go after him, neither Medicaid nor the providers can. Now, turning to the reasonable charge issue, first of all, obviously, plaintiff has the burden of proving that a charge is reasonable. Under the Spectrum case, other evidence, including Medicare reimbursement amounts or Medicaid reimbursement amounts, can be offered into evidence to show what a reasonable charge would be. Here, you've got Medicaid that issued a payment. You've got homeowners that paid the amount that Medicaid charged. A jury presented with that information could conclude that, hey, they've already been paid a Medicaid payment amount, and we determine that's reasonable. I mean, the issue of fact, whether something is reasonable is ultimately a question for the jury. And if a jury is presented with payment information from Medicaid saying, hey, this is what Medicaid normally reimburses, a jury could conclude that that's a reasonable rate. And then if you look at Mr. Miller's deposition testimony in this matter, first of all, I think his credentials are suspect in that he worked at a company as a biller without any specialized education or training as a biller, no training in coding. Those are all issues that I think a jury can consider in analyzing his testimony. With regard to the conflating reasonableness and customary, the one thing that Spectrum and all the cases stand for is that those are two separate inquiries, and both of which have to be proven. In his testimony, he testified that in his mind, reasonable, and I can pull the exact site, but essentially he testified that he was using reasonableness and customariness synonymously, essentially. And I think that's conflating those two standards of proof. And a lot of times, if you look at what the customary charges are, they talk about the 80% charge. That's not saying that's a reasonable charge. That's saying what's customarily charged by hospitals. And so to me, that's conflating what is reasonable and what is customary. It's not looking at what their overhead is. It's not looking at why they charge what they charge. I mean, those are all things that must be proven separately from what a customary charge is. And I don't think the plaintiff has met their burden of showing why this is a reasonable charge. They may have met their burden of showing it's a customary charge. But as for reasonableness, I think that's lacking. And because they haven't established that through Mr. Miller's testimony, there's no obligation to produce any contrary evidence to that effect. So, I mean, those are the reasons that we would ask that this court deny the motion. And respectfully, we still stand by our position that we've argued previously that there has been no expense incurred, and Mr. Wilson has essentially no legal liability for these claims, and they should be dismissed.
All right, thank you, Mr. Sinus. Do you have rebuttal?
Yes. First of all, with respect to this idea that Marquette General Hospital has said that it cannot claim any money in this case is just not true. They've had an attorney on this case corresponding with us as the representatives of Myron Wilson. And in Kathy Hagman's deposition that's been given to this court, I think both by way of their response and also our reply brief, there's a question asked to her. It says, so you were not here to make an official statement on behalf of Marquette about what the legal rights are of Marquette to pursue its charges that were incurred on its billing statement in this matter. Yes, I'm not an attorney. Okay, thank you. And she also acknowledges that she's not, doesn't have the legal authority to speak on Marquette General's behalf. And so what she did is she answered questions about whether that's her understanding of the law, that when Medicaid pays, that they can't bill the client. She also acknowledged, though, that she's not an expert in the no-fault law. And this court has issued an important legal ruling that gets into the nuances of when these two systems happen to interact with one another or get intertwined. And that's what all these Court of Appeals cases are about. And so there's a legal ruling here that gets at the heart of the matter, which is, does Myron Wilson have the right, and do his providers have the right to assert the reasonable charge even when Medicaid is paid? And when either way you cut it, the courts ruled on that issue and ruled in such a way that's consistent with Michigan appellate case law. There is really no case law that supports exactly what they're saying. And so, but moving on to this issue of deciding or arguing that their distinction between reasonable and customary creates a genuine issue of material fact, it's very important to understand that we're talking about 80% of charges. This is something that could both be reasonable and customary, and has been asserted that way by us. And they have never responded to our case saying it's not. It should be 60%. It should be this amount. So yes, in the context of no fault litigation, there's a wide spectrum of evidence that could be asserted by the parties to use to create a dispute over reasonable charge or to prove reasonable charge. But what we've done is we've decided to go forward and prove it the way we've proven it. And they have not said anything substantively in response to that, certainly not in their discovery responses, which I said they've never formally asserted in this case. And now we hear a last-ditch attempt to use the Spectrum case, where the no-fault insurer had already paid 80% of the charges, to say that somehow they're creating an issue of material fact by talking about Medicaid rates when they still talk about them as being relevant for the incurred requirement. So I say, and obviously this is my position, but what I urge the court to do is to let this process go forward on the appellate stages where they really want to go to with this incurred requirement, and recognize that as a matter of Michigan court rules and how cases are litigated, they have not created a genuine issue of material fact on this particular issue of reasonable charge. Thank you.
All right, thank you. Well, first, I'm just going to briefly address this issue of whether the expenses were incurred, because when I do so, I will have now ruled 3 times on the same issue and the same arguments. So despite the defendant's claim that something has changed because defendant homeowners has now reimbursed Medicaid, nothing has changed, or at least nothing has changed legally. I would refer everyone, and I know you know this, but to the transcript from the August 8th, 2018 hearing, the motion for summary disposition, pages 27 to 32, because I made what I thought was a pretty comprehensive and complete ruling on those pages. And I said that the Hicks case is controlling, and something else that I know everybody knows, but anyone watching this might be scratching their head. I think it's an important point here. The plaintiff wasn't eligible for Medicaid. The Medicaid benefits were paid and the plaintiff wasn't eligible, just like the plaintiff in Hicks. The plaintiff was not eligible in Hicks for Medicaid either. So anyway, back to my reasoning in 2018, Hicks is controlling, and although now in this case, again, the defendant has argued that MCL 400.111B somehow changes things, I addressed that back in 2018 and ruled that it changes nothing because the plaintiff was ineligible for Medicaid benefits. So how the two systems interact, it makes a world of difference when you're talking about someone who really isn't medically indigent and not eligible for Medicaid benefits at all. So with that, I'm going back to, and when I say I've ruled on it 3 times, there was a motion for reconsideration, which I looked at this whole thing again and denied the motion for reconsideration. So this is now the 3rd time. I refer you back to my ruling in 2018. And I again find that the expenses were incurred. Going now to the next issue, which is what the plaintiff's motion was really based on to begin with. The plaintiff is seeking a ruling that the charges incurred were reasonable. And in support of that, the plaintiff has the affidavit and the deposition of his medical records expert, Mr. John Miller, or medical billing expert, pardon me. And the plaintiff has argued that they have this evidence from Mr. Miller to support the reasonableness of the charges, and the defendant has nothing contrary, nothing to create a genuine issue of fact. For this issue, I have looked at the Spectrum Health Hospitals versus Farm Bureau Mutual Insurance case. That's the one that just came out in the fall of last year. And I think that it is binding and it is dispositive. It says in that case that the provider's charge has to be both reasonable and customary, two separate analyses. Customary is based on what that provider charges for a like product, service, or accommodation in a case not involving insurance. And that customary doesn't necessarily establish that the charge is reasonable. That Spectrum case went through a lot of factors that could be considered in deciding whether a charge is reasonable. One is, and it's not the only one, and no one I think is dispositive, and this one that I'm about to mention is a little dicey since the plaintiff didn't qualify for Medicaid, but still, if the provider is willing to accept a Medicaid payment, then that is a factor that the trier of fact could consider in deciding whether the charge was reasonable. So there's a lot of other factors that are discussed in Spectrum Health, but the bottom line is that in Spectrum Health, which right now is my binding authority, it concludes whether the amount charged is reasonable is ultimately a question of fact. And I think that's because of the multiple factors that they talk about in that case as weighing into the reasonableness of the charge, and again, including some of the ones that are present here. I don't think that I can, under Spectrum Health, rule that because the plaintiff has produced a medical billing expert, that's the end of the story, and that both customary and reasonableness have been shown with no issue of material fact. I think it is an issue for the trier of fact. While I understand what the plaintiff is saying about what the defendant's ultimate goal here is, I can't cooperate in meeting that goal because I think that under Spectrum Health, I cannot. So I am denying the defendant's motion for partial summary disposition. And someone will need to do an order that reflects for the reasons stated on the record. I don't know who's going to do that, but
I can do that, Your Honor. Thank you.
okay. Thank you.
Judge.
Thanks.